The summary hearing was held on June 28, 2016 to question whether there is a reasonable prospect that the applicant can prove that his code rights were violated. On March 2015, the applicant, Wayne Russell, submitted his resume for a transit operator position. He attended a driver's information session in August 2015 and was invited to an in-person interview with the respondent, the Toronto Transit Commission, in September 2015. The interview took place on October 5, 2015 and lasted about 1.5 hours. In regards to the email he received on November 4, 2015 that he was no longer considered for the position, the applicant asked the interviewer for the reason. The interviewer responded, "As you are aware, you are ranked mainly on the 12 behavioral interview questions. Some you did well with your examples, but unfortunately, there were several that were okay but not strong." The applicant responded to the email questioning how his answers to several questions negated his years of experience in customer service and transit driving, in which he did not receive a response to. The applicant claims that such decisions were made on discrimination against his age by someone in senior management, and their reasoning of poor performance on the behavioral questions were just to hide such discrimination. The respondent claims that discrimination against age was not made. The respondent was aware of the applicant's age as early as when the information session occurred by his driver's license and current driver's abstract, which both contained his date of birth. The applicant scored 52% on the behavioral questions that were also asked to other candidates and did not meet the cutoff to the next stage, which was 60%. While the applicant did not disagree with the respondent's position, he claimed that his clean driving record on large vehicles, superior training, and receiving an award in his previous employment for customer service excellence made him score above average on the cognitive testing, thus was qualified for the job. The applicant allies that he was discriminated against his age because he has not seen the respondent hire anyone his age or older since he has been applying. The applicant claims that it is a gut feeling that he did not get hired, as he finds it hard to find a reasonable reason as to why he was not hired as opposed to his coworkers who were. Although he claims that these coworkers are younger, the applicant did not provide an evidence that those who hired were younger. He also admits that he is on a fishing expedition for the truth. The summary hearing is relatable to the case of Dabic v. Windsor Police Service, at which the tribunal made the following observations on the type of inquiry that may be involved in a summary hearing. In some cases, the issue at the summary hearing may be whether, assuming all the allegations in the application to be true, it has a reasonable prospect of success. In other cases, the issue at the summary hearing may be whether there is a reasonable prospect that the applicant can prove, on a balance of probabilities, that his or her code rights were violated. Often, such cases will deal with whether the applicant can show a link between an event and the ground upon which he or she makes the claim. So, does the applicant have a reasonable prospect of providing that his rights under the code have been violated by establishing a link between the respondent's action and his age? The decision was made to dismiss the application. The applicant provided sufficient evidence to prove that his rights under the code have been violated. For an application to continue in the tribunal's process following a summary hearing, the basis should be beyond mere speculation and accusations. The applicant has made some allegations based on his observations without presenting any evidence that would demonstrate that he has a reasonable prospect of proving a connection between his age and his experience of not progressing beyond the hiring process. Discrimination against age is growing every day, and yet age discrimination is difficult to prove and thus most cases are not pursued. The Ontario Human Rights Commission, OHRC, states that following considerations may suggest that age was a factor in not hiring an applicant. Few from their list are if the employer indicated qualifications at any stage of the recruitment process which can be interpreted as a euphemism for age, such as, "Do you think you can handle this job?" It takes a person who is full of vim and vigor. Also, if there is a pattern in the past hiring or employment practices of the employer suggesting a preference for or an institutional bias toward younger workers. One can also accuse discrimination against age if the applicant's qualifications for the job were as good or better than those of the person hired and the person hired was significantly younger than the applicant. The last two considerations suggested by the Ontario Human Rights Commission is applicable to the applicant, Wayne Russell, according to his allegation, which suggests that there could have possibly been discrimination against his age during the hiring process. So the question is, was it appropriate for the tribunal to dismiss the application?